Prova, 1, 2, 3, 4, 5, sì, sì, sa. Prova, 1, 2, 3, prova, prova, 1, 2, 3, prova, prova, 1, 2, 3, 3, 4, 5, basta. Prova gli altri? Aspetta, deve essere uguale, insomma. Sì, sa, prova, prova 1, 2, 3, 4, 5, 6, 7, 8, sì, sì, prova, prova, prova 1, 2, 3, prova 1, 2, 3, prova, prova audio, prova, prova, prova 1, 2, prova, prova, sì, sì, sa, prova, sa, prova, 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 microfono, prova, 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 prova. Prova check 1, 2, check. Check 1, 2, I want you to, 2, 2, 3, 4, 5, 5, 6, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6. Prova 6, prova 7. Ok, continuo. Sì, sì, prova. Ok, registra. Sì, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, sì, 7, 8. Prova 9, prova 10. Prova, prova microfono, prova. Prova 1, 2, 3, prova 5, 6. Prova sì, prova sa, prova, prova, prova volume microfoni, prova volume, prova, prova volume, prova, 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 prova. Tu prova, prova. Come senti? Senti bene? Sì, mi senti? Che ci vuoi fare? No, ma hai equalizzato bene? Sì.
Ok.
Sì.
Because basically here you have got plenty of
Wow,
space.
we have
and
lots
so,
of space.
you know,
Per quanto tempo parlerà?
No, io pochi minuti, nel senso...
5 minuti, 10 minuti?
No, 5, più di 5, ma forse non arriverò neanche a 5, insomma, voglio prendere tempo.
Ok, ma io penso che non cominceremo
Puntuali.
Allora abbiamo 5 minuti no, credo 15 minuti per noi tre.
No, ma va benissimo.
Perché secondo me dobbiamo cominciare alle 9:30 con il convegno.
Benissimo.
Vabbè, altrimenti siamo Hans Miklit.
Volevo presentare di questa perché l'anno scorso feci una domanda e le volevo comunicare che quest'anno è stato un successo, sono stata finanziata, però quest'anno sono in Inghilterra, quindi buongiorno. Ho rivisto il progetto anche alla luce dei commenti dell'anno scorso, quindi sembra una istituto, però insomma comunque la ringrazio tantissimo per la sua gentilezza.
Eleonora, senti, allora io sì,
Ma
te poi
forse
devi
sarà
fare
un'altra possibilità, no?
Speriamo.
Ma sì, credo di sì.
Grazie ancora, comunque per il suo supporto molto gentile, anche da noi ci si conosceva. Sono stata sui paesini del professor Cancione.
Ah, ok. Sì.
Culturali, quindi
Sì.
bene, è stato un piacere.
Grazie.
Poi mi farebbe molto piacere. Anzi, sì.
Siamo colleghi,
Sì,
no?
sì.
Siamo colleghi, siamo in Italia.
Sì, ma mi farebbe molto piacere una volta averti a pranzo, a colazione da me,
piacere.
insieme a Wilder, professor Wilder, per verificare un pochino la possibilità di ulteriori iniziative come questa, comuni, immaginare anche altri momenti che per noi sarebbero molto importanti.
Con piacere. Come si fa?
Spingere il bottone verde, se no non mi sente nessuno.
Buongiorno, buongiorno e benvenuti nella sala di Dugento. Io sono Cristina Giachi e sono la vice sindaca di questa città e stamattina ho l'onore e veramente il piacere e anche l'emozione di dare il benvenuto all'Istituto Europeo, al professor Miklitz, al rettore dell'Università degli Studi di Firenze, Alberto Tesi, al presidente dell'Istituto Europeo Joseph Weiler, a tutte le autorità, ai professori e permettetemi ai cari professori della facoltà a cui appartengo e a parlare di fronte ai quali mi emoziono sempre, più che di fronte a tutte le platee. È molto bello ricordare stamani a Firenze Mauro Cappelletti, e non lo dico da giurista, perché il diritto troppo spesso passa per essere una scienza di forme lontane, quando invece è una forma di metafisica sociale, di luogo in cui si pensano le categorie dell'agire quotidiano, e troppo poco i giuristi sono considerati uomini di vita attiva, anche quando studiano e fanno ricerca nelle loro biblioteche, tra i loro libri. Mauro Cappelletti ha ispirato gli studi giuridici contemporanei, ha fondato il diritto comparato e ha lavorato qui a Firenze. Per questo stamani ricordarlo in questa sala è un segno non solo dell'importanza del suo lavoro e del suo ruolo, della sua figura, ma anche di quanto le città e le comunità vivano di queste figure e del loro lavoro. Ecco, lavorare in questa sala, come io dico sempre, questo non è il salotto di Palazzo Vecchio, questa non è la sala delle feste, questa è la sala da pranzo, è la cucina, è il luogo dove si lavora. Qui da 700 anni si cerca più o meno di amministrare il bene comune, di decidere per la collettività. Ecco, lavorare in questa sala vuol dire contribuire a creare discorso sui temi che più segnano la crescita civile, lo sviluppo civile della comunità, che è una città, che poi è un paese, che è una coinè di studiosi, che è la nostra Europa, sulla quale ancora c'è tanto da fare. Ecco, voi avete un compito, voi dell'Istituto, importante come unica istituzione universitaria europea. È un onore averla a Firenze, è un onore ricordare figure come Mauro Cappelletti che fin da principio hanno caratterizzato il lavoro dell'Istituto. Benvenuti a Palazzo Vecchio e buon lavoro. Do la parola al professor Tarli Barbieri, direttore del Dipartimento di Scienze Giuridiche dell'Università di Firenze.
Grazie. E ringraziando il comitato scientifico del convegno, sono veramente lieto e anch'io emozionato di portare il saluto del Dipartimento di Scienze Giuridiche dell'Ateneo Fiorentino. E lo porto molto volentieri e con emozione per diversi motivi. In primo luogo è da sottolineare che questa importantissima iniziativa nasce da una collaborazione tra l'Istituto Universitario Europeo e appunto il Dipartimento di Scienze Giuridiche. Una collaborazione certo non nuova, ma che spero possa svilupparsi ulteriormente nel futuro, alla luce di una feconda e multiforme attività di ricerca delle due istituzioni che, sono convinto, potrà trovare ulteriori momenti di confronto e di collaborazione. Da questo punto di vista, un passo sicuramente significativo è dato dalla recente approvazione di una convenzione tra l'Ateneo Fiorentino, con il coinvolgimento in particolare proprio dei dipartimenti dell'area delle scienze sociali, e l'Istituto Universitario Europeo relativa allo svolgimento di attività didattiche e di ricerca comune, in un contesto nel quale, come si legge nelle premesse di questo testo, è reciproca volontà e preminente interesse delle parti sviluppare rapporti di collaborazione e di cooperazione reciproci. È poi da ricordare che a questa iniziativa ha dato un contributo importante anche la Fondazione Cesifin Alberto Fredieri, che costituisce una realtà fondamentale sul territorio nell'organizzazione di studi e convegni sulle più rilevanti tematiche giuridico-finanziarie ed economiche. Ma c'è un altro motivo per cui oggi porto volentieri e con emozione questo saluto. È il fatto cioè che qui siamo in un convegno dedicato a Mauro Cappelletti, un grande maestro a cui l'Ateneo fiorentino non può non essere veramente riconoscente. Personalmente non ho avuto la fortuna di conoscerlo, ma il suo pensiero è stato davvero fondamentale anche nella mia formazione. Tra le sue numerose e fondamentali opere devo qui ricordarne una in particolare, il controllo giudiziario di costituzionalità delle leggi nel diritto comparato, pubblicato da Giuffre nel 1979, ma con una serie di saggi in realtà precedenti. Questo testo è qualificato dall'autore nella presentazione come un volumetto e più tardi dice un cursiglio, ma in realtà non si tratta né dell'uno né dell'altro, ma di un'opera lucida che in chiave anche storica ricostruisce in modo originale i modelli di giustizia costituzionale. È un'opera di fondamentale importanza, tanto che ancora oggi è ampiamente citata in dottrina. Penso, solo per citare un esempio, alla voce Giustizia costituzionale comparata di Alessandro Pizzo Russo, pubblicata nel primo volume degli Annali dell'Enciclopedia del Diritto. Come dicevo, si tratta di un'opera davvero fondamentale e illuminante e che ha, precorso linee e sviluppi che si sarebbero manifestati assai dopo. Mi ha in particolare colpito un passo nel quale l'autore già intravedeva, e lo cito, un mutamento di prospettive che caratterizza il mondo culturale e sociale della nostra epoca e in cui ogni esperienza si va sempre più inserendo su un piano internazionale e sopranazionale. E tale mutamento, a suo giudizio, avrebbe imposto giustamente la necessità che il metodo della ricerca giuridica dovesse, e lo cito ancora, ovviamente aggiornare i propri strumenti, in un approdo inevitabile verso una più ben vasta ricerca appunto, lui diceva, di nuclei comuni sul piano internazionale e universale, ricerca di confluenze e di divergenze, di consonanze e di dissensi tra i vari ordinamenti e tra le varie grandi famiglie giuridiche e delle loro ragioni pratiche e ideali e delle generali tendenze di evoluzione. Oggi ricorderemo Cappelletti come studioso della giurisdizione, del processo e del processo costituzionale in particolare. Ma vorrei qui ricordare che è stato anche un giurista impegnato nelle tematiche relative, ad esempio, alla riforma dell'università. Ancora oggi di grande interesse appaiono diversi contributi pubblicati nel volume L'educazione del giurista e la riforma dell'università del 1974. E in particolare nel paragrafo conclusivo di un saggio dal titolo Studio del diritto e riforma dell'università italiana, l'autore, dopo aver espresso considerazioni critiche e vorrei dire disincantate sulle prospettive di riforma allora in discussione, e stiamo parlando del 1973, concludeva auspicando, e cito ancora l'autore, la nascita di un tipo di università che, senza sopprimere l'importanza del merito individuale, eviterà le situazioni di iniquo privilegio sociale, di un'università che, senza togliere, anzi accentuando il controllo sugli arbitri e sugli abusi, incoraggerà flessibili adattamenti ed esigenze sia individuali che istituzionali, locali, regionali e persino internazionali e sovranazionali. Di un'università, infine, che senza lasciarsi sommergere nel caos di anarchiche avventure didattiche, si imporrà come formatrice di menti critiche e creative e non come consegnataria di un sapere staticamente tramandato. Credo che queste affermazioni di grande attualità ancora oggi acquistino un significato più pregnante appunto nell'attuale momento storico, nel quale appare di tutta evidenza come queste affermazioni appaiano ancora largamente da conseguire. Anche per questo però l'eredità di Cappelletti ha da essere coltivata per essere tramandata anche ai più giovani studiosi. E ringraziando quindi per l'attenzione e la partecipazione, auguro a tutti i convennisti un buon lavoro. Grazie.
Major Florence, Matilda Cappelletti, amici, friends, colleagues of Mauro Cappelletti. Today it's my honor and my pleasure to welcome you to this conference entitled The Process and Constitution, the Heritage of Mauro Cappelletti. Mauro Cappelletti was born in between the two wars, and during his lifetime, he, among others, contributed in no small part to the re-edification of Europe, in particular by placing law as a framework in which to tame the political vitalism that gripped the interwar years. He lived a long life, passing away 10 years ago in 2004. Speaking now at the remove of some 70 years, we might lose sight of the achievements of the post-war generation. And yet, once again, we live in turbulent and uncertain times for Europe. Different are our challenges, to be sure, yet today we look back to reflect on Cappelletti's contribution to legal scholarship and how it might harness to face these contemporary challenges. Cappelletti was a professor at Stanford University in the United States and in Europe, at the universities of Macerata and at Florence. Between 1976 and 1987, he was professor at the newly founded European University Institute. His legal thinking, his academic life, his political conviction, his way of thinking, his single-mindedness in bringing Europe and the US closer to each other can only be explained against the background of the post-war. Mauro Cappelletti was deeply convinced that the promotion of law and the strengthening of justice was crucial for the establishment of a better world. For Cappelletti, as an Italian cosmopolitan, this meant a Europe of peace and prosperity, Europeans living together in respect and, where possible, in friendship. 4 research themes were developed by and inspired Mauro Cappelletti throughout his life as an academic and as a researcher, namely access to justice, integration through law, judicial review, and civil procedure, all held together by a comparative legal method which combined the letter of the law and its practice, law in context. The 4 themes together could be understood as the 4 pillars on which federal legal orders rest. The 4 themes are timeless. The surrounding political, social, economic context may change, and as such, their meaning might change. Even their relative importance might change. These 4 themes, however, are sufficiently foundational, such as to allow us to cope with the continued unfolding of European integration, be it the tricky process of European constitutionalization or the ever-increasing role of human and fundamental rights in European law and beyond. The 4 pillars guide and assist us in the search for the role and function of law and justice. It is Cappelletti's intuition for the fundamentals of a legal order and his endurance which led him to spend his entire academic life deepening our understanding of these fundamentals. In the final analysis, it is this which makes Mauro Cappelletti such an outstanding scholar. Indeed, this is the impressive legacy which he has bequeathed legal scholarship. Let me conclude by just saying a few words on his place and the role he played for the EUI. He has left a deep and lasting impression on the law department of the European University Institute. Without doubt, Cappelletti contributed substantially to the building and shaping of the EUI law department's identity in the early years of its existence. The 4 themes, access to justice, integration through law, judicial review, and civil procedure, form an integral part of the EUI Law Department's history, identity, and might I say vibrancy. This is not to speak of the comparative legal method and law and context thinking, which turned into a genuine and distinguishing feature of the EUI Law Department. So the time has come to celebrate and pay tribute to our eminent colleague, Mauro Cappelletti, in the only way academics can do this, by openly and critically discussing his work, its past and its future. Thank you very much.
Buongiorno e benvenuti nel Salone di Dugento. Good morning and welcome to Florence in the Salone di Dugento. Le lingue ufficiali di questa giornata dedicata all'opera di Mauro Cappelletti sono due, italiano e inglese. E allora, anche se la prima sessione, quella che ho l'onore di presiedere, si svolgerà esclusivamente in inglese, cercherò di usare l'una e l'altra in un mix che spero non risulti troppo strano. The official languages of the conference are English and Italian. And even though the speaker and the discussants of this first session will make their presentation in English, I will mix English and Italian, hoping that the result would not be too strange. I tempi della giornata sono molto stretti e il mio ruolo è solo quello di farli rispettare, perciò dico solo due cose molto piccole e introduttive. E le dico soprattutto per i più giovani, che qui sono molto felice di vedere numerosi. Che cosa è l'Access to Justice Project? Chi sono le persone chiamate a discuterne il valore attuale? Today's timing is very tight, and because my role is only that of checking the clock, checking the watch, I have just two very preliminary things to say, especially for the young public. What the Access to Justice Project is, who are the persons called to discuss its present value. The Florence Access to Justice Project was a comparative research project sponsored by the Ford Foundation and with a slightly more local focus by the CNR, il CNR, the Italian Council of Research. The project resulted in a 2,700 pages, a 4-volume collection published in 1979 under the general editorship of Mauro Cappelletti. The revolutionary general report introducing the project was authored by Mauro Cappelletti and Brian Garth. The project changed the meaning of the words access to justice, and the famous 3 waves, legal aid, legal representation of diffuse interests, global, we would say today, access to justice approach, have since then become common language. The second point, Brian Garth is therefore the inevitable speaker of this session. After his PhD at the European University Institute, he has been professor in many prestigious universities. Presently, he teaches at the University of California, Irvine. He is Director Emeritus of the American Bar Foundation, author of dozens of books and hundreds of articles. The discussants are Ilaria Vianello and Giacomo Pailli, representing the 2 institutions sponsoring today's event. Ilaria Vianello presently holds a PhD researcher position at the European University Institute. She also holds an LLB with honors from Maastricht University and an LLM from the UI. Giacomo Pailli, I like to say that he's a genuine product of the Cappelletti School. He graduated from the Department of Comparative Law of the University of Florence, founded by Mauro Cappelletti in the mid-60s. He also holds an LLM from NYU. Le presentazioni sono fatte. Prima di dare la parola a Brian Garth, consentitemi di leggere, a proposito dell'importanza del tema di questa prima sessione, che cosa scrivevano Cappelletti e Garth, appunto, nel General Report significativamente intitolato access to justice, the newest wave in the worldwide movement to make rights effective. The right to access is increasingly recognized as being of paramount importance among the new individual and social rights, since the possession of rights is meaningless without mechanism for their effective vindication. Effective access to justice can thus be seen as the most basic requirement, the most basic human right of a modern egalitarian legal system, which purports to guarantee and not merely proclaim the legal rights of all. Professor Garth, the floor is yours. Thank you.
Thank you very much. I'm honored and a little bit intimidated to be here in front of this group of people who were my mentors long ago, and talking about Mauro Cappelletti, who was, of course, my principal mentor. I do want to start just by saying how I came to the project. I was a third-year law student at Stanford, and I was planning on working in a law firm in Palo Alto. I saw a notice on a bulletin board that said Research Fellowship in Florence. I had never taken comparative law. I had never met Mauro Cappelletti, but I applied. As Kim Economides said, it was access to Florence. So I was one of 3 Americans who came and was selected, and I postponed my Palo Alto law firm for 1 year, I thought. So 39 years ago, I started working for Mauro Cappelletti after graduation. My main duty first was to help with correspondence, essentially taking dictation and then putting it into proper English so we could send the letter. It had me a little bit worried at the beginning about what I had signed up for, but as it turned out, it was a wonderful journey. My 1 year turned into 3. We all moved, John Weisner and me as students, and Mauro Cappelletti as professor, to the European University. And I never practiced law, ever. So my stay here really made my academic career, and by the way, saved me from practicing law with the rise of the Silicon Valley in Palo Alto. So I want to talk a little bit about the Access to Justice Project, what it did in 3 parts. I want to talk about the project itself, although we already have a nice introduction. Then I want to say what happened to the positive vision of that project. And then more speculatively, I want to talk a little bit about the context for the project. We know how many volumes and pages it produced, all in basically a 6-year period. That's a lot of work, if you think about that. It covered North America, South America, Europe, Asia, some Africa, and also Australia. There was a volume even on anthropology. There was a volume on access to justice in the welfare state. And what was the line of the project? The line was a very strong normative position dressed up as a description of 3 ways of a worldwide movement to make rights effective. The idea, as was already stated, was we had activists and welfare states, new constitutions, even transnational ones, all seeking in some way to benefit the relatively disadvantaged and unrepresented. And it was time, the project asserted, to make these rights real and not merely symbolic. And it came, as we heard, in 3 ways. The first was that legal aid moved from charity to some kind of entitlement. Then there was the representation of diffuse interests, like the environment through class actions, public interest law, relator actions, the ministère public. And then the third wave, which was to be more systematic, was innovation in dispute resolution machinery, alternatives to courts, changes in the rules even, like no fault, changes in the legal profession, like paralegals, new forms of legal practice. But all of it was to focus, in this third wave, on the realization of the regulatory aims and the rights of the activist states of the 1960s and 1970s. What are the basic achievements of this project? Everybody here could come up with their own list. My list will be very partial, in both senses probably, but let's talk about a few. One is the project kind of brilliantly anticipated and helped fuel the alternative dispute resolution movement in the United States and elsewhere. Two, it pushed civil procedure scholars to confront serious political and social issues, to step out of their comfort zone, and it provided a vision, a lasting vision, of how that might be done. Third, and we don't realize how novel this was at the time, Mauro Cappelletti insisted that the project should have detailed empirical work in civil procedure and on access issues at a time when few people did that kind of empirical work. Fourth, and I think this is an innovation that's stayed with us, it really brought public and private approaches together, both contrasting them, but also seeing them as complementary in some very creative ways. And then this one, I think, also was probably underappreciated, is it gave prominence to legal anthropology and to legal sociology, and to groups emerging at that time connected to law and society in the US, but also in Britain and the Netherlands in particular. It came out just as Mark Galanter's seminal article on Why the Haves Come Out Ahead was published. It tied in with the people who really produce public interest law firms in the US, some of the intellectuals behind that, like Joel Handler, David Trubeck. So it brought together pioneers in the sociological and political study of rights and social movements in law. And we could go on. Now, what did the project not achieve? Well, the first thing it didn't achieve was we didn't get to making rights effective. It was already evident by the late 1970s that alternative dispute resolution, as it was emerging, was more of a privatization of justice. In fact, the third wave was in part a way of cooling down the explosion of rights. And we actually said in volume 3, because we could kind of see it coming, that access to justice movement and its opposite could be very similar. So for example, and this could be multiplied as well, we now have highly tailored dispute resolution by elite private judges, such as international commercial arbitration, versus, on the other hand, consumer disputes that are channeled to low budget and even biased industry-sponsored machinery. Class actions are on the defensive in many places, especially in the United States. Legal aid funding has been cut everywhere. It's more of a focus on charity and pro bono than ever, although there's something good things that can be said about that. When you talk to legal aid people in the United States, they're talking about phone advice and not exactly the most innovative and adventurous advocacy that you might like. Judith Resnick, a scholar at Yale, very much imbued with the access to justice approach, writes of the privatization of process inside courts, as well as the devolution to agencies and outsourcing to private providers. The new procedural forms, she says, close off public access by citing dispute resolution outside the public sphere. So those are my first two parts, some estimate of what the project achieved, some estimate of what happened to resist that move to make rights effective. And now the third part is a little more adventurous. This is a little bit of legal sociology. Now, why legal sociology? Because this is the project that Mauro Cappelletti most embraced legal sociology in. And in a way, he moved on after access to justice. But of course, I did not. I stayed right where I was. And I only got deeper into it. So if you get me, you're going to get some legal sociology. And I owe that to Mauro Cappelletti. So my general focus for quite a number of years now has been on change in the role of lawyers in relation to globalization and the import and export of governance technologies, and on the rise in particular of what you could call US-style globalization. I've worked for many years with the French sociologist Yves Désolé, and that's been our general focus. So 2 stories to suggest why that focus might be interesting as a kind of a legacy of access to justice. In 1992, partly because, or largely because of the work on access to justice, I was invited to go to Argentina for a World Bank judicial reform project. I talked to many people there, and they kept asking me about mediation and alternative dispute resolution. As a good comparative procedural scholar, I kept saying to them, you know, you come out of the civil law model, we have an access to justice, the Stuttgart model, we have other things, active judges, you don't really need to worry much about American-style mediation. I did the best I could, and what did they end up with? Exactly American-style mediation. It wasn't necessarily that it was the best available option, but it was the most prestigious option for them. And they had been to Harvard, they'd studied dispute resolution there, and they were going to bring back their Harvard expertise and put it to play in Argentina. The second example is doing research in the late 1990s with Yves in Brazil, and we were looking into reformers who were changing the role of courts, particularly judges, under the new constitution, the relatively new constitution. We were looking for a judge in the South who was supposed to be one of the leaders, and her name was Gracie Northfleet. I called her up, she answered the phone, and I said, my name's Brian Garth, I would like to interview you, and she says, I'm honored to speak to you, Professor Garth. I'm the one who translated Access to Justice into Portuguese. She ended up being the chief judge of the Brazilian Supreme Court. So we won't do it now, but the question for sociology of law is how did that trajectory, what does it tell you about what was going on in Brazil and globally at the time? So now what about the Access to Justice Project? And I hope this is not too crude, but it'll be a little bit crude. What led Mauro Cappelletti to Access to Justice and to the Ford Foundation and to this kind of US orientation? Part of the puzzle is he had mastered civil procedure and the procedural formalism, drawing on German approaches, etc., needed to rise in the Italian system. He had the technical virtuosity that he needed to succeed. But he rejected it loudly and expressed almost contempt for that kind of work with huge lectures, formal, dogmatic reasoning. And he stepped out of that at some cost, I think, to himself and to his assistants, and moved into a US allied project that essentially ignored Italy in the project. So the question is, was it his anti-fascism, his alliance with Calamandrei, maybe a kind of outsider status of the old legal elite families? I'm not sure, but I think whatever reason, he moved in a way that was quite pioneering. And it might just be they were smarter than anyone else and saw how US approaches were really going to gain prominence. Now, what led the Ford Foundation, the funder of public interest law in the United States, at just that time, and also the funder at just that time of the emerging human rights movement in places like Chile, South Africa. Why did they fund an Italian to lead a project on access to justice in Florence? Well, it's a bigger topic, and just a hint is that the same groups in the US who were promoting the rights revolution as a way to moderate social change in the 60s by opening up US society to new groups, they also sought to moderate social movements abroad, not, as in the Cold War, by supporting anti-communist authoritarian governments, but by strengthening the role of law, lawyers, and democracy for a post-Cold War world. Their focus was on the soft power of ideas and institutions leading to the spread of US-friendly states. But a comparative project based in Florence and headed by an Italian, how does that fit? Well, it fits brilliantly in a way because Mauro Cappelletti could translate that general approach to law and state into a very subtle and complex comparative narrative with private and public combinations. And that wasn't simple. There were developmental states in this project, there were socialist countries in this project, European social states, and in all of these, lawyers and legal solutions were not so prominent in addressing social problems. So the worldwide movement in the general report, in fact, drew very little on the national reports in Volume 1 because different roles of law were actually being enacted. But in doing that, it provides a way to build a new narrative that can really resonate, for example, in Brazil. And it does so today. You know, I already talked a little bit about it, but every week, Google Scholar tells me that that Brazilian translation has been cited at least 2 or 3 more times. So it's very much alive in Brazil. And also the Access to Justice project could be used at home in the United States by the Ford Foundation and people allied with it. Because what they could say was, look, the rights revolution is a worldwide trend. You know, we need to re-import it back into the US. And indeed, President Jimmy Carter had a group called the Office of Improvements of Civil Justice, and they used the Access to Justice project very much to try to build momentum for keeping these approaches alive. But the very same process of exporting and then re-importing trumped this access to justice approach. The neoliberal economists who they could say in the US had some success in Chile and then import that back really overwhelmed the rights approach. So I'm not going to go farther on that, but the point is that the Access to Justice project was a microcosm of broader global trends, sort of building the US approach of the law and state. We could talk now of the proliferation of corporate law firms around the world, new and reformed law schools training corporate lawyers, which didn't happen in the past, Bucerius, Boccone, Sciences Po, Getúlio Vargas. So there's a lot going on that's consistent with this. So what can you say out of this little foray into sociology of law? Well, you don't really need to hear it in a discussion of access to justice. But for me, it actually enhances the achievement of Mauro Cappelletti because he figured out what human agency to exert in this structural picture. So what did it accomplish then, looked at in this other way? One is that the translation that he made matters and continues. This was not the virtuosity of the procedural scholar, but the virtuosity outside of legal formalism. Again, he brought it to civil procedure, and it highlights the fact that a successful entrepreneur, and he was a great entrepreneur, must anticipate which directions society is moving and be there in that anticipation. So he had the timing and sense of history after the Cold War. It's true that neoliberalism ascended and killed the positive access to justice program, but law, lawyers, legalization, judicialization are all over in the past decades of globalization. So my conclusion is about that entrepreneurialism and where would it be today? Where would, if Mauro Cappelletti were alive, where would he be taking us? I don't have his entrepreneurial sense, but I bet, and other people could talk about this, that there would be volumes and insights on the new global issues. I would imagine that he would have procedural scholars talking about international courts, including international criminal courts, truth commissions, law of the sea tribunals, the WTO, international investment arbitration. He would be pushing a new agenda, and it would be extraordinary what might be learned and what impact it might have. But so far, I think, because we don't have him, they are outside of the domain of civil procedure, and I think that's too bad. Thank you.
Thank you to Professor Garth for his fresh description of the project, and especially for being so perfect in timing. And now I give the floor to Ilaria Vianello. Please, Ilaria.
Thank you. Good morning. Before I begin, I would like to thank the organizers for giving me the valuable opportunity to be here today. I'm also a bit intimidated, as Professor Garth says, not only because there is a big me behind me, but also because I believe it's the first time I speak in front of such an esteemed audience. It is a real honor for me to talk about the work of Professor Mauro Cappelletti, not only because he was one of the most famous and prominent Italian scholars, but also because in his study of the law, he was careful to take into consideration those individuals that all too often are invisible in our society. He showed courage and open-mindedness in criticizing the lawyers who conceived the legal system as an autonomous word. In contrast, he took a contextual approach by looking at the law from a law and society perspective. By looking at access to justice from this angle, the existence of a gap between the liberal idea of equality before the law and the reality of unequal access to justice for many in society became evident. As Professor Garth just mentioned in his talk, Professor Cappelletti moved scholars away from the highly technical studies of civil procedure formalism to the substance of access to justice and the effective realization of legal rights. I believe that Professor Cappelletti and Professor Garth's extraordinary project on access to justice is still relevant today. And in this brief comment, I hope to highlight one of the main reasons why I believe this is still the case. So in line with Cappelletti's contextual approach, as elaborated by Garth in the third part of his speech, I will first try to explain how new societal developments are putting pressure on the concept of access to justice. Secondly, I will briefly explain how the Florentine project on access to justice can help new research projects find innovative solutions to these new developments. 50 years ago, the legal imagination centered on governance within and by nation-states. The domestic legal system was the paradigm, its architecture clearly defined, its modus operandi largely one of command and control, and its autonomy unquestioned. 50 years on, the landscape of legal governance looks very different. Governance within the nation-state no longer respects a simple division of the public and the private. In many cases, hierarchical organization has given way to more complex regulatory networks, and each particular regulatory space is characterized by its own distinctive regime of governance and stakeholding. In this new global arena, there seem to me to be three new barriers to access to justice for individuals: complexity, the blurred line between legal and non-legal norms, and, in certain cases, the lack of an international forum where individuals affected by an international measure can obtain justice. I will outline these three barriers in turn, in line with the methodology used by Cappelletti and Garth in their work. It is undeniable, I believe, that in recent years, global governance has grown more and more complex and difficult to map. Numerous international agencies now regulate fields that are in some cases narrow and specialized, and in other cases broad and general. This area beyond the state is not only global from an economic point of view, it is also global from a legal perspective. It is characterized by a vast number of regulatory bodies, detailed rules, numerous procedures, and by a complex array of relations and networks that link together state and non-state actors. Faced with a space lacking a clear dividing lines between global and national, and between horizontal global sectors, individuals who do not necessarily have the means to comprehend such an intricate situation feel more and more in a labyrinth, lacking a clear path to effective justice. The word complex and complexity are increasingly gaining momentum also in the vocabulary of academia. For example, Professor Paul Craig, in one of his recent articles on economic governance and the euro crisis, uses the term complex and complexity 15 times in 20 pages. In addition, we have seen an increased use of so-called soft law. In domestic legal orders, there is normally a clear dichotomy between legal and non-legal norms. The picture, however, changes as we move into the global arena. For example, many World Bank instruments are simply referred as to policy documents, yet in many cases it is hard to consider them less important than statutes passed by national parliaments. As Professor Sabino Cassese highlights in one of his articles, these type of instruments regulate important aspects of the bank's activity, such as the duty to perform an environmental impact assessment and all relevant procedural requirements. Private parties in South Africa and India can appeal to these standards and ask that the global and national government bodies comply with them. However, in many other countries, it becomes extremely difficult to challenge this soft law measure, even if it can potentially have a significant impact on the life of individuals and society as a whole. Finally, on top of the obstacle of complexity and the increased use of non-binding instruments, there is the lack of institutions providing access to justice to individuals who are directly affected by an international measure. Do I have in mind here the famous Mr. Cadi? Yet, to a certain extent, yes. However, what I really have in mind here are all those individuals that were not as wealthy as Mr. Cadi and objectively did not have access to justice when they saw their assets being frozen. In fact, it was only in 2009, as a partial response to the famous Cadi decision, that the Security Council issued a resolution and provided for a quasi-independent and impartial administrative view of listing decision. What I'm trying to portray here is not a total lack of courts or tribunal in this global context. Judges are present in the global arena. However, they are not organized in a comprehensive system, and the obstacles for individuals to obtain effective access to justice are still varied. For example, some courts are only open to states. Numerous research projects seem to be in place in order to understand how these new barriers can be overcome. The increasing proliferation of research institutes, including global governance in their name, are a concrete example. Another illustration is provided by the Global Administrative Law Project that, among others, explores the possibility of finding common global principles such as due process, the duty to give reason, independent review, and ways to enforce them in the international arena. My PhD project, for example, represents an example of a subcategory of a broad search of ways of guaranteeing access to justice on a global scale. Specifically, it analyzes ways of guaranteeing access to justice to non-EU citizens affected by union measures, often non-binding, that are addressed to third countries. All such efforts, varying from a research institute, extensive research project, or simply PhD projects, aim at finding ways of ensuring effective access to justice at a global level, and still have much to learn from Professor Cappelletti's work. The Florentine project on access to justice is still alive, insofar as it can guide, both through its methodology and its content, the movements aimed at ensuring effective access to justice on a global scale. Methodologically, it is important to bear in mind the conclusion of the famous general report by Cappelletti and Garth. There, the author suggests that in order to tackle new categories of claims, it is necessary to adopt a functional and multifaceted approach, focusing on claims that face particular type of barriers, involve particular type of parties, and cover certain areas of substantive law. Furthermore, Professor Cappelletti studied the topic of access to justice from a comparative perspective, in order to find positive convergences among different legal traditions. In this respect, I would not completely exclude the possibility of using a comparative approach also at a global level by comparing different regulatory spaces and finding positive convergences. Content-wise, the Florentine Access to Justice project represents a source of inspiration in as far as it focuses on the full panoply of institutions and devices, personnel and procedures, aimed at offering also alternative out-of-court tailored solutions to specific type of disputes. As Professor Garth stated in his lecture, the empirical research is essential to study of how procedures actually work in practice. The three waves and the challenge to the legal profession are still out there. In conclusion, having in mind the Florentine Access to Justice project, The question to be asked now is whether we are facing or will be facing in the near future a new fourth wave of access to justice movements that try to make individual rights effective on a global scale, or whether we are witnessing yet another example of the third wave movement that fits into what was defined by Cappelletti and Gard as the new access to justice approach. I personally do not yet have an answer to this question. However, in line with Professor Gard's conclusion, I do believe that access to justice in a global arena needs to be extensively explored. In particular, the focus should be on access to justice for individuals. The globalized context is putting under pressure the real substance of access and effective realization of legal rights for individuals. Thank you.
Thank you to Ilaria Vianello. Even if rights are still not effective, unfortunately, I think that we can understand that the project is still alive and we still need such a project, and maybe we should look for a fourth wave, as probably Ilaria suggested. Now is Giacomo Paili's turn. Thank you, Giacomo.
Thank you very much, Professoressa Berzotti. I also associate myself to thanking the organizers for giving us the chance to speak in such a beautiful room. And the Access to Justice project was, in Cappelletti's view, a legal movement with two goals: making a legal system first to be equally accessible to all, and second, to lead to results that are individually and socially just. I believe these two goals are the same goals we need to pursue today. For sake of time, I will focus my remarks only on the second wave, the protection of what I call diffuse or collective interest, and to me says class action and private enforcement. My first remark relates to the shift of social paradigm and its consequence on the law, particularly on procedural law. The French Revolution, after centuries of differentiation and particolarism, handed to us an admirable construct, the unification of the subject of law, soggetto di diritto, under one definition, and apologies for my French: les hommes naissent and demeurent libres et égaux en droit. But rules and schemes that were built upon the liberal idea of the bourgeois citizen owner of land, with a one-rule-fits-all approach, sometimes fail to adopt to today's relations that have departed from this model. Disputes more often see isolated consumers and users on one side and facing complex multinational corporations, hardly comparable one to the other. No doubt that one party cannot match the resources and power of the other, which often outweigh even public regulatory authorities. Cappelletti clearly understood this when he focused on the massification and serialization of society. The loss of individuality and of specificity turns individuals into groups and classes of homogeneous rights or claims holder. I believe this is still the starting point of any policy-oriented analysis today. As a byproduct of this new massive dimension, Cappelletti put at the center of his thoughts, as Professor Gatt suggested, what he called the new social rights, with social also meaning collective in Cappelletti's view. The examples he gives are environmental, health, discrimination, perhaps consumer-related rights. What he did not have before his eyes, of course, was the unimaginable development of the internet, for instance, the increased importance of privacy rights, and the related concept of big data, which seems to be the ultimate massification, if I may. I would also add an increased focus on human rights. And I share Professor Gard's suggestion that Cappelletti would have paid attention to these new rights, new dimensions, adding perhaps to the table online dispute resolution with its unexpressed potential of being a cost-effective means of solving modern consumers' disputes. Cappelletti also devoted much energies to the analysis of the various forms of enforcement of rights, encouraging scholars to explore a variety of reforms. There are many approaches to protect new collective rights. These range from public enforcement, and we heard ministère public, or in a more modern way, regulatory agency, mixed approach, and private enforcement approach, the last modeled after the idea of the private attorney general. I believe we should not have any taboo here. In particular, in Europe, we should pay greater attention at empowering private parties. Hidden in the figure of the private attorney general, in fact, is the consideration that private parties asking for a private remedy can, in certain conditions, vindicate a greater public interest. Without obscuring the need for public enforcement of public interest, private attorneys general help solving the practical consideration that public regulatory bodies lack resources and sometimes interest in, to act in any and all situations. So the two models of enforcement, private and public, should be viewed as a complementary and not mutually exclusive parts of an efficient and modern way of achieving an effective enforcement of rights, one that is not satisfied of purely formal declarations. This is also linked to the idea of deterrence as a function that should be played by rights enforcement. Rendering economically unfeasible or inconvenient for a business to engage in a certain practice means neutralizing all its profits arising out of that practice. And private enforcement, sometimes through collective actions, can be the only way of achieving such deterrence, the only practical way of achieving such deterrence. And I come to our last point before actually rapidly turning to class action. Ilaria already noted that in our modern society, issues and disputes easily transcend the national borders, adding a new transnational dimension and calling for a necessary global enforcement. This is my part, of course, if deterrence is to be achieved. This is a dimension that was not at the center of Cappelletti's work, I think, but it cannot be ignored today. And there was a time when US courts seemed to play the role of a global court capable of redressing global wrongs wherever happened and however characterized, including through global class actions. Professor Garches noted that class action is being severely limited domestically in the US. I add that as far as transnational disputes are involved, the US Supreme Court is clearly closing US doors to foreign plaintiffs, as well symbolized by decisions such as Ampagram, Morrison, and Kiobel. Something has changed in the role that US judges think they should play in the world order. Is it good or bad? I don't have an answer, but my hope is that the fading of one forum could renew a global debate on the answers that might or should be provided by other players to new transnational and global issues, and Ilaria, of course, said something about that. I will be very much interested in knowing what Professor Gatt thinks of it. Coming to class action, Cappelletti said that the new social collective diffuse rights and interests can be protected only by new social collective diffuse remedies and procedures. Therefore, collective and class actions are a necessary means for granting a real and effective access to justice to mass and serial disputes. This does not make us unconditional enthusiasts of class actions, which still should be seen as an extremely valuable instrument only if accompanied by adequate controls, not to mention cultural issues such as acknowledging a different function for judicial proceedings and a different role for litigants, lawyers, and judges. With decades of US experience before our eyes, we should not overlook the risk of abuse of this powerful instrument, as well as the problem of accountability for private enforcement choices. But there are natural forces within the society, including egoism, which could and should be channeled for the benefit of the system as a whole. As Cappelletti noted, and I quote, while critics of the class action have suggested that attorneys are the main beneficiaries of the class suit, they usually neglect to point out that at least the public interest is being represented and without substantial cost to the public. As to the features that a class action should have, I will focus here only on one, perhaps the most important, the dilemma between opt-in and opt-out as a participation mechanism that in Europe we have very present. Empirical evidence shows that class members usually do not take any action. They do not either opt in nor opt out. By adopting a concrete access to justice approach, it is clear that if we want class action to work, we should no doubt embrace opt out. Italy's recent law on class action is a perfect example. The law is not bad per se, but by featuring only an opt-in mechanism, it simply does not work in practice. It has the name of class action, but not teeth. Opt-out should not be seen as a betrayal of the right to be heard and a corruption of traditional principle of res judicata. Rather, it is a shift from an individual to a social, meaning collective, notion of due process of law. And as Cappelletti said, Even the most sacred principle of natural justice must be reconsidered in view of the changed needs of contemporary society. The counterbalance to, let's say, this sacrifice is a focus on an adequate representation of group interest by the class champion. Another interesting aspect that Cappelletti underlined is the plan of remedies. Here I can only mention the need, for instance, to have some component of punitive damages if deterrence is to be achieved. And I'm well aware that this concept is alien to European culture and much opposed. Finally, class action alone is clearly not enough to ensure an effective private enforcement of ordinary people's rights. I make reference here that sometimes no discovery or no disclosure of documents means simply no access to justice at all. And it's interesting that European lawmakers are starting to making interesting experiments in this sense, such as in the Enforcement Directive on the protection of intellectual property. All the devices that I have mentioned, class action, discovery, punitive damages, can and maybe too often are abused by unprincipled plaintiffs and greedy lawyers. Nonetheless, each represents an attempt to answer today's challenges, and each should be seriously taken into account either as a paradigm to be followed or as an invaluable term of comparison for European experiments in this direction. These are certainly not the sole possible answers. Cappelletti said that the desire to make the rights of ordinary people real calls for far-reaching reforms and for a new creativity. And this is the most fascinating features, he said, in the modern evolution of judicial law. Now, to conclude, allow me an introspection. Professor Sabarsotti kindly presented me as part of Cappelletti School, and I thank her for that. I think she's right, but I realized it only preparing for this conference. Much like the man who discovered he had built talking prose his entire life, I discovered reading the general report and studying Cappelletti's work deeply that I resonate with many of the ideas and priorities that Cappelletti set a long time ago within the access to justice movement and which look very current today. And I think this is the single most valuable contribution I can make today. The heritage of Cappelletti is not only large, modern, and up-to-date, but is walking on new legs, and not necessarily only my legs. And in thanking you for your patience, I have to admit that I feel quite reassured because it seems that I'm walking on the shoulders of a giant. Thanks.
Thank you, and thank you especially for making my task very easy, because the speaker and the discussants were very precise in timing. So I think we can take a little bit advantage of this preciseness in timing and see if Professor Gart has a few remarks on what Dr. Vianello and Pailli have just said about perhaps this necessity of thinking about a fourth wave for the project.
I'm happy to do so, but mostly I'm happy just to have such bright members of a younger generation picking up some of the challenges of the project. It's fun for me to listen to these really sharp ideas, and just a couple of comments about what a fourth, if you take seriously the notion that in some ways the global legal architecture is a projection of a US legal architecture. Within the US you have a kind of equilibrium of the private law firms representing business and these pretty well-funded public interest organizations that can battle them, maybe not on even terms. But when you shift to the global, what we have is we have all these forums, as you suggested, all this confusion, but the big corporate law firms know how to play the different forums. They can fight something here, they can fight it there, but there's an asymmetry. The global public interest side, the private attorney general side, is not there to chase that around. It's partly there, but not at all there in the same way. I'm not positive I know how to make a wave that will, cover this over, but I think it's a problem, and it's also a problem when you look at the economic side versus the more human rights side. The WTO expands, international commercial arbitration extends, intellectual property. They all move almost seamlessly, capture new domains, new countries. But when you look at international humanitarian law, universal jurisdiction, all of these are highly politicized, and they don't move in a parallel fashion. And so again, if you were looking for ways of making this architecture more effective globally for access to those who have diffuse interests, claims of human rights and the like, you need to somehow make more parallel these structures.
Thank you again, and I think that we will need young surfers for this new fourth wave. And now I think we can announce the coffee break. Was this wrong? Okay, okay. Professor Miklitz, Hans, do you think we have time for a little bit?
Minutes.
Oh, we have 20 minutes. Okay. Okay, so penso che abbiamo tempo, magari facciamo sedere le persone che sono appena arrivate. Penso che abbiamo qualche minuto di tempo per qualche domanda, per un po' di discussione. Come vi avevo detto all'inizio, farò un mix di italiano e inglese, quindi penso che potremo accogliere domande, interventi sia in italiano che in inglese. E penso anche che ci siano i microfoni, quindi penso che possano essere fatte direttamente dal posto. Qualcuno che rompe il ghiaccio, che alza la mano? Somebody would like to start for a little discussion? Okay, thank you. Please. Would you say your name first?
My name is Valentina Vadi, Lancaster University, United Kingdom. I have a question for Professor Garth. You mentioned a previous work of yours with sociologist Professor Yves Dazelet, and I was wondering whether access to justice for corporate actors, that is to say investment arbitration, may be something that can constitute a progress for corporate actors, but at the same time also somehow highlight a huge divergence in access to justice for some actors that are better off with regard to other actors who may not have the same privileged venue. And I'm referring to indigenous peoples and minorities, and thank you for your reflection on this. Thank you.
Thank you for your question, and your question is also a comment, and I think, of course, it's right. When you talk about international commercial arbitration, international investment arbitration, it's high quality justice, organized to effectively resolve, more or less. I mean, investment arbitration is under challenge, but organized to resolve disputes among large corporate entities. And there certainly doesn't exist in the same way for indigenous groups, and some of the ways that were kind of carved out, that were mentioned, that maybe weren't designed for this, like the Alien Tort Claims Act, where people would sue in the US for violations of indigenous rights by Chevron or whoever, and that's essentially been taken away. It was not necessarily designed for that purpose, but it provided a kind of ad hoc, more or less at least publicity forum for that, and even that's not there now. So you're right, it's part of the asymmetry that I was talking about. It's a very different world for each side.
Yes, please.
Ralph Rogowski, University of Warwick in United Kingdom. Continuing this topic of what to do at the global level, And there might be one dimension that was not really central to the Access to Justice project, but which we might want to think about now when we think about maybe a fourth wave or the global level. And that's the civil society. And that is the possibility of civil society organizations operating at the global level. And their involvement, Amnesty International, Greenpeace, and I've been involved with Transparency International fighting corruption at the global level. They do actually engage in thinking about and setting up new possibilities of giving citizens a chance to engage and bring their complaints at national level, but because of their global operations, they can use their international and global capacities to make rights effective at national and local levels. And thinking about the connection between global, international, and national and local levels might be way ahead.
Yeah, thank you for your comment. I think that a key word of what Professor Gar said in his comment is asymmetry. So asymmetry of resources. So I completely agree with you. I mean, big organizations like Transparency International and also the environmental organization are very important key actors. And I think that a way of guaranteeing access to justice, in a way, is to equalize power. So I agree. I mean, corporations for sure are extremely skillful in playing around in this complex environment, while individuals or also NGOs and civil society. And I also would like to say that not only civil society, I think that there is now also a new rise of movement, social movements. Certain countries now see a big rise of social movements, really grassroots, and I think this should also try to have a stake in the global arena. Thanks.
I can add one point, which is, and this is something that Mauro Cappelletti wrote about, there are sometimes questions about the accountability of major civil society actors, that are sometimes well-funded by foundations and are more responsive, let's say, to concerns that gain attention in the New York Times than they are mobilized for concerns that might gain attention in some other places. So there are issues, but you're right, that's where you look for where something might be developing that can police that conduct in a better way.
If I may just add, accountability is a big problem in all public interest litigation. Not only who funds you, but how you make your choices, whether to pursue one thing or not the other. And taking up your comment, coordination, international coordination of local actions I think is a powerful instrument, but you need to have then local actions, so you need to have, let's say, a real access to justice at the local level, meaning, for instance, representation of diffuse interest or class actions or other means of proceedings.
Other questions, comments, please, from the floor? Yes, please.
My name is Ulrich Petersmann from the European University. Access to justice is inevitably related to how you define justice. And you know that the definition of justice in American constitutional law, the American adversarial mode of litigation, is completely different from the definition of access to justice in the EU Charter of Fundamental Rights. Now, we are currently in a very crucial situation where Europe and the United States, Europe and Canada renegotiate transatlantic free trade agreements where you can argue that we are agreeing on an institutional bias against access to justice. For example, investor-state arbitration permits direct access to powerful investor companies, but no direct access for individuals to justice. no direct access for consumer organizations which represent general interests. So the question is, do we not need urgently, because the negotiations on the TTIP or on the Canadian Free Trade Agreement are probably concluded next year, do we not need urgently more research on these asymmetries in transnational litigation, which we see in the WTO, in the United Nations, in human rights courts? There is nowhere, neither in the International Court of Justice, nor in the WTO, nor in UN human rights law, effective access for individuals to justice beyond the state. And the question is, in these very important negotiations on the TTIP, the Transatlantic Free Trade Agreement, do we not need more research on how we can limit this institutional bias favoring powerful non-governmental business actors, but discriminating systemically against individuals and general interests which remain diffuse?
Well, I'll respond with absolutely. That there's no question about that. And there is some research. The research is not about exactly how the tilt of the results, but it's the tilt of those who produce the results, because the results of investment arbitration depend on who are the investment arbitrators, and that world is the subject of some research which tells you a lot, and whether or not that world is going to shift and accommodate people who are more sensitive to the interests that you talk about is an interesting. I think that world itself knows that it's in a crisis of legitimacy right now, and it'll be interesting to see if it moves. But there's a whole domain. Makes me realize that it'd be great to organize another project on some of these things, because no one's doing that kind of systematic research, which we obviously need to do.
Let me overstate a little bit. The access to justice idea was developed in the 1970s. The world looked different. Yeah? It was a world very much inspired by the United States, which was also the leading moral entity, if I may say so. Yeah? So producing and promoting ideas of justice, certainly with a certain reservation that Uli Petersmann highlighted. But my question is the following. In 2014, we have a different world. Yeah? And if we want to look really outside the US-EU context, and if we want to integrate the world after the enlargement of the EU and the inclusion of China and India, I'm wondering whether we can so easily build our world and our categories in this kind of thinking. And there are, from the little that I know, but if you look into China, or if you look into some of the Eastern European countries, so the forms of dispute settlement that you may easily criticize for a number of reasons may be the only means to get a little bit of justice. Yeah? And there are often no courts to which they can address. And in what I can take from the tradition of what Mauro Cappelletti has left us is certainly to look into reality and to look what's going on and to look into law and context. But it all boils down to the question really to be more careful in implicitly or without really wanting to impose Western ideas and cultures of how society look like or should look like to the rest of the world. And to my mind, there is a word of caution needed here.
Thank you, Hans, for taking us back to methodology, I think, which is important.
Again, that's a very good point. One thing I would point out is one of the beauties of the Access to Justice project is you have a little of almost everything there. And so the discussions on Africa and indigenous rights in particular focus very much on legal pluralism, on what are the ways of preserving the best out of indigenous dispute resolution. So I think the idea to the second part of your question was not to try to impose any kind of, even if I suggest it's an Americanization, it's not to impose American models necessarily around the globe. There was a certain tolerance, even celebration of, I remember the Bush lawyers in Indonesia and various things in other places. But in terms of the bigger question about where we are now with new global powers arising, when we're talking about global architecture, global approaches, one of the things I think it's very important to see is that this U.S. architecture, which really looks like private law firms, civil society, law, rule of law, which is very much modeled. It's a projection in a way of the U.S. market and approach. It cannot be taken for granted. It also is contested. It could be that Chinese, Brazil, whoever comes and says, you know what, we don't like this model anymore. We think that we should be governed by a focus on other governance languages and approaches. I don't see that happening in the near future, but that's something that we always have to be explicit about. And the U.S. post-Cold War approach, which so much highlighted, respect for rule of law, legal institutions, in the days of war on terror, with the publication of our torture report yesterday, it makes it harder to maintain the credibility of that approach. And it means it can be challenged at other levels as well.
And I also share, I think your comment is absolutely right. I just pointed here a quote that I did not read from Cappelletti. And he said, the evident need is to preserve the course while creating other more accessible forms. I think this can be one key. I mean, we need options, and perhaps other non-adjudicatory options, other options that look to other values can be fine, but still we need to focus on options such as the courts that come from our tradition, from the rule of law, from the judicial enforcement of rights, I think.
We have time for another question, comment? Or everybody is ready for coffee? Okay, I think this is the answer. Everybody is ready for coffee. Thank you again.
Coffee is downstairs.
Allora.
Accendetelo e parlate abbastanza vicino,
Sì.
non vicinissimo con questi, ma abbastanza vicino, perché questa stanza ha dei problemi.
No, hanno detto alle 15, secondo me.
Ah, ma non devono
C'è
già...
autodisciplina, no? In questa sala.
Speriamo.
Allora.
Mi raccomando, perché abbiamo bisogno. Okay, can we start this session, please?
Oh, if I say this, it will be an hour. So I'll cut.
But so you didn't know in advance it was 20 minutes?
Maybe I did not want to pay attention, you know.
Ci sono arrabbiatissima, quindi ci vediamo così.
Okay, so I'm very pleased to start this session, Integration Through Law. This is a fantastic opportunity for Florence and for the two academic institutions. Can you hear me now? Yeah. Thank you. Okay. As I said, this is a fantastic, extraordinary occasion for Florence and for the two academic institutions organizing the event, and I'm very honored to be here today. There are several reasons why I feel proud to be here, because I've been very privileged to be in both universities, the EUI and Florence University, and I must say with no sense of split loyalty, because both institutions are so engaging for people working in them. And this is, I think, a moment when we remember Mauro Cappelletti's heritage and contribution to legal scholarship. I've known him personally in Florence in the late 80s when a group of comparative labor lawyers was meeting in Florence for a project. And I was assisting that group as a young research assistant, and we were invited to the splendid home of Mauro Cappelletti here in the neighborhood of Florence. And his curiosity towards other discipline was, to me, the best introduction to his work. And of course, as a labor lawyer, I've known him as one of the strong reformists for the reform of the Code of Civil Procedure, in particular with labor law cases. And he was engaged in this meaningful reform of the Italian Civil Procedure Code. And part of that intelligentsia in the 1970s in Italy, which transformed so many branches of Italian law. We are very lucky here today because Professor Azoulay, who is sitting next to me and the speaker in this session, holds the chair of European law at the European University Institute. He is also a co-director of the Academy of European Law and the Center of Judicial Cooperation, in itself a sign of continuation with Mauro Cappelletti's work. He's been active and is active in many editorial and scientific boards of prestigious journals. And so I think as an imaginative writer, as he is, he will be able to guide us through the very imaginative research path that Mauro Cappelletti started with the Florence Integration Project, as it was called, which I think that project continues ideally here today. And there is a continuous discussion on legal pluralism and what legal pluralism meant to Cappelletti. It meant many, many things. For example, there are different ways of interpreting the role and the function of comparative law, because comparative law for Cappelletti was a mean to an end and served the purpose of really going beyond legal formalism and capture the function of legal institutions. But then also comparative law for Mauro Cappelletti meant to test the accountability and the democratic accountability, in fact, of institutions. And hence, this is a very powerful lens through which we can look at the interaction of many sources of law, including the law made by judges, which was so much at the center of attention in Mauro Cappelletti's work. Integration through law is not a merely I should say, theoretical study on federalist systems. Neither it is a projection into the future of the potentialities which were inherent in the community then born around a common market. I think it is really the origin of many other research projects. For example, the Florence integration project throws light, even today, on future comparative work, which has been carried on at the European University Institute with a constant attention to preliminary ruling procedures as a way of studying integration through law, and to this community of judges which was built around the enforcement of EU law. So integration through law is looked at in a very dynamic way. It is an ongoing process, and we are all aware of the very many difficulties of such a process in current times, and I'm sure that we shall have a critical appraisal of this in Professor Azoulè's paper. And I immediately give the floor to him, but let me say a few words on the brilliant discussants we are lucky to have here today. Marta Infantino, a doctor in comparative law, holds a postdoc position at the University of Trieste, and she is also a member of the Council of the European Law Institute. I'm very proud to say, as an Italian woman, that I'm glad that you are there and developing also the Italian contribution to such a prestigious institution. And she works in the Common Core European Private Law project. And Martin van der Slees is a PhD researcher at the European University Institute, mainly a constitutional lawyer, if I read correctly your work, and very interested in the current issues of Euro crisis, and contributed with a very interesting chapter in the book edited by Adams, Fabrini, and LaRouche. So we're really very grateful for your presence today. I have to be careful in watching the time. So the floor is yours, Professor Azoulè, and please can you stay within the 20 minutes that have been assigned to you. Thank you.
Thank you very much. Grazie molto. I will try to keep on the time. Mi fa un grande piacere per me essere qui con voi oggi. I am most delighted and honored to be here on this occasion to celebrate Mauro's Cappelletti legacy. Actually, I didn't have a chance to get to know him, but I read part of his work, especially when working on my thesis a few years ago. Now, I would like to talk to you about the concept of integration through law, precisely by relying on a reading of the general introduction to the series. This text, the introduction to the volumes, co-authored by Cappelletti, Secombe, and Weiler, is more than merely an introduction. It is an extraordinarily rich and insightful essay. And in this essay, the authors tell us that, quote, European integration is fundamentally a political process. It is not mainly a legal process. Yet, this does not lead them to detract from the fact that law, quote, has a vital role to play in this process. Indeed, throughout the text, the authors essentially deal with the question, how does law operate in a non-legal context in order to produce a form of flexible federal union in Europe? And we are still asking this question. The context, however, has dramatically changed. When the Integration Through Law project posed this question, law had long been presented as a natural driving force of the process of integration. You may remember Walter Holstein famously stated just a decade earlier in the 70s, the European community is a remarkable legal phenomenon. It is a creation of law, it is a source of law, and it is a legal system. And the rule of law was supposed to replace force in European politics. Law was presented not only as a functional tool, but as a cultural, as a symbolic form, as a carrier of a new spirit of cooperation and loyalty and solidarity as a medium to contain political, economic, and social forces, as well as a cement to hold these forces together. What the introduction to the Integration Through Law project makes very clear in 1986 is the difficulty of finding a way for this form of integration to flourish in times of economic and political crisis, in times in which member states withdraw into the protection of their own national and economic interests. In the introduction, the authors clearly acknowledge the limits of law. And yet, the role of law as an effective and symbolic integrative force is not challenged. Now, our difficulty is different. Our difficulty is to find a way to pursue integration in a context not only of a profound and multifaceted crisis, economic stagnation, rise of nationalism, crisis of political representation, external threat on Europe. Not only that, but a widespread mistrust in the positive force of law. The narrative of law and integration standing in an intimate and positive relation is over. And so the question of integration through law has now to be defined in a context of a broader process that is legally structured not only by homogeneity, equal treatment, inclusion, but also by increased form of heterogeneity, inequality, exclusion. That would be at least the way in which I would reformulate the question. And so, from the beginning, I would say, we have two problems. The first is to ask what it means to integrate Europe through law in a context in which law is but one of the many instruments to achieve integrations. And certainly, as the authors of the introduction make clear, certainly not the critical success factor. First problem. The second problem we have is the following. What form does this question take for us now? How does our contemporary context of European integration condition the concept of integration through law? Or in other words, what does integration through law mean in a legally distorted context? Now, the first author to articulate compelling answers to the first question was Pierre Pescator in a book entitled The Law of Integration, published in the French original version in 1972. And not by chance, integration through law, starting in 1978, stands in a chiasmic relation to the law of integration. And in many respects, as I see it, integration through law is an attempt to address the shortcomings of the law of integration's construction, while at the same time sharing the assumption that the integration process is engaged in a unique and valuable process of building a new economic, social, and political order. And so, to discuss integration through law, I think it makes sense to situate it with respect to this earlier construction, the law of integration. Both projects, integration through law and the law of integrations, are predicated on the assumption that integration is a field fraught with contradictions. And we know that integration is an order-building enterprise, but it largely depends on member state structures, member states' rule, member state institutions, and it depends also on foreign cultural references. And so the question is how to make this tenuous, precarious process sustainable. And the law of integration actually has a twofold answer to this question, has a twofold approach. The first one consists in providing, or rather, I would say, revealing the structure of support that will sustain the process. And in Pescator's view, this structure lies, I quote, in a grand idea of order, an idea of order which floats above politics, which is determined by the existence of common values, and to which, I quote, participants are ready to subordinate their national interest. There is an idea of order floating above politics and floating above member states. And the representative of this idea of order are the European institutions, operating through law. So you see, in this view, integration is not only a creative process, it is an order. It is an order which defines its telos. And the operation of European law must reflect this telos, the telos which underpins the process. And it should be clear that this very sophisticated construction has had a great performative effect in shaping the discourse and practices in the integration process for a long time. Also because the law of integration was not only an intellectual enterprise, it was also a sort of practical device. It was part of a strategy of control over legal and political minds to promote the goal of integrations. As you may know, Pescator was a judge. He was part of a milieu of jurists, jurisconsults, who circulated amongst the institutions and conveyed a shared culture of supranationalism in support of integration. And actually, this mobilized legal community is what a new generation of sociologists and historians calls integration through law. So, you see, there are two ways in which the law of integration attempting to overcome the gaps on which the integration process was originally based. First, by putting forward a structural approach to European law, this idea of order, and second, by a deliberate confusion of theory and practice. Now, as I see it, the integration through law project is an effort to expose the fallacies of this concept. Integration through law rejects, I quote the introduction, the temptation of a model of integration characteristic of the early days of the European community. Actually, it seeks a conception of integrations free of any ideological connotation. And to do so, it relies on two methodological shifts. First shift is to use comparative law. To use comparative method as an instrument to provide, quote, from the introduction, a yardstick for objective evaluation of the integration process. The advantage of comparative analysis is that it avoids the appeal to a telos, the appeal to universal principles, by its very nature as a method which relies on an inevitable tension between similarities and differences among legal systems, which in that case are federal systems. That's the first shift. The second shift is from law to governance. The project intends to explore not only the content of law, and the introduction is very clear about this, but also what they call the pre- and post-normative phase, that is, the process of lawmaking and the impact of law on the ground. So, you see, behind a positive account of law, the project looks into the real processes by which law is negotiated and implemented. These are the two methodological shifts that we find in this project, and actually they have proved to be incredibly fruitful in the field of European study, especially the second one, especially the turn to governance, because this has prompted a special interest in European studies, in economic and political factors, and also a special interest on actors and relations between actors, especially relations between courts. Comparative law is a more difficult task to carry out, and so the reception of this shift is less established, I would say. These are the two methodological precepts that we find. It has been fruitful. However, as a basis for a neutral framework of analysis, what Cappelletti called a laboratory for analysis, scientific method, they were problematic. The reason is that the project remains tied to the vision of integration as a federal experience. And I quote, with a view to future progress. Here we find this in a central passage of the text. The author makes clear, I quote, that, very striking expression, it is a legal order that we are expounding. It is a legal order that we are expounding. This, of course, strongly resonates with what US Chief Justice Marshall famously wrote in 1819 in McCulloch versus Maryland. We must never forget that it is a constitution we are expounding. And there it's a legal order that we are expounding. And of course in Europe, there is no federal demos to which this new federal order may be ascribed. And moreover, the authors of the project refuse the telos which has been suggested by Pescator. They refuse the telos of the common market. They refuse the telos of the political unification of Europe. And so what do? Instead of a telos, since there is no federal demos, what integration through law places at the core of the integration process is an ethos, not a telos, but an ethos. The challenge is to build a European constitutional order based on the value of the person and in a manner which respects and involves all the participants at all levels of government. And actually, this is reflected in the two meta-principles put forward by the authors in order to organize the wide matter to be analyzed. One is called, in the introduction, the basic European identity, and the other is called the federal principles. And it should be clear that these two principles are not only organizing principles for the research, but they are truly normative principles. On the one hand, European identity is a way to bring, and I quote, a new dimension, the dimension of the rule of law and justice, which is based on the respect for the individual, a concern very much in the mind of Mauro Cappelletti. And for the authors, this is best encapsulated in the area of free movement of persons, with the migrant worker treated as a person, provided with a social and family status based on human dignity. On the other hand, the federal principle is meant to ensure that a sufficient degree of participation of pluralism is admitted in the decision-making process. And the perfect example for the authors is the field of foreign policy, because foreign policy ensures that there is equal participation of all players. Now, I want to talk a little bit about resilience. In the course of the introduction, it becomes clear that by relying on these two principles, the authors intend to reform the process such as to make it resistant to the new and forthcoming crisis. The project is very much about making integration resilient in the face of crisis from within and outside. And now the question is, has European integration proved to be resilient? And what can be said of European identity and the federal principle in the European Union today? And if time's allows, I will just say a few words about these two dimensions, European identity and the federal principles in Europe today. On both counts, the picture does not look so good. First of all, the development of a genuine European identity has met with strong resistance. Its merits and its effectiveness are now questioned. Take the British Prime Minister's immigration speech given 10 days ago as an impressive, even though elusive, confirmation of this point. The speech given by David Cameron was clearly an attack against what integration through law perceived as a core of European identity. He reaffirmed the importance for UK of being part of the Union, but at the same time, he calls into question the notion of personhood constructed by European law. To recall, we can understand EU law as striving to secure social ties and personal identity beyond and across the boundaries of national jurisdiction. Now, it is to this kind of identification, to this form of identification, that David Cameron opposes the notion, and I quote in the speech, the notion of common home and what he calls the national club, which should be preserved. And therefore, he suggests more control on free movement of persons and the imposition of new conditions on entry of migrants. What I want to underline here is that Mr. Cameron is far from alone in holding such a conception. It has to some extent now reached the European institutional world, as illustrated in the Dano decision issued by the Court of Justice on the 11th of November. In Dano, in this decision of the Court of Justice, we see clearly that the Court of Justice loses sight of the aim of citizenship, which is to ensure the integration of Union citizens into the society of any other member states. Instead, the Court focuses on the objective of preventing Union citizens from becoming an unreasonable burden for the host member states. So this is the first aspect, European identity, you see, in a nutshell. Now, the federal principle. We also have an institutional practice which seems to deviate from the federal principle. The federal principle rests on the idea that European integrations constitute a global system in which viewpoints may vary depending on the institutional level in question, but to which all participants, Union institutions, member states, and citizens are bound and committed, each one in its own place. And I think the strongest claim in federal system is a claim of commitment and loyalty made upon member states and citizens. Now, we are experiencing the development of disturbing phenomena which seem to challenge this claim. And we see that in many areas of the European construction, but it's perhaps most visible in the field of economic and monetary union. And here, the practice pulls in two opposite directions. On the one hand, we see the development of a space in which the member states and union institutions develop their actions outside the institutional and legal framework of the EU, relying on international treaties, contractual arrangements, domestic private regime. This shift toward new forms of action, new procedure, reflects in a situation of tight mutual dependence, in a situation of interdependence. This reflects distrust in the EU institutional machinery and its effectiveness. But it reflects, more broadly, a lack of commitment to the idea of a whole, to the idea that the Union is more than the sum of its parts. On the other hand, we observe the Union or its organs interfering in areas where the member states are supposed to act. We see heavy centralized intervention taking place in areas of supposed national autonomy with respect to budgets, taxation, pensions, and so on. This is what has been called a system of executive federalism. Now, it should be clear that this is a sort of federalism completely alien to the federal principle referred to by integration through law. Here, cooperation among actors and representative institutions are replaced by monitoring compliance and executive dominance. So in a way, this, and I will briefly conclude, in a way, these observations on the changes affecting European identity and the federal principle, they point in the same direction. They lead to the same result, a profound transformation of the process of integration. It is no longer integration through law in the classic sense. What is left of law is a body of rules, mainly conditions, sanctions, standards, without an ethos. What is left of integration is the realization of a form of factual and economic interdependence without a deep sense of mutual membership. And this is for me the challenge now. The challenge of integration today is how to build a relational space in Europe that reflects more than mere economic, legal, and political interdependence. How to do that? How to have a relational space going beyond interdependence? I don't think that this can be done by simply returning to the foundational values of the EU, to the values of the EU. It has been made plain, I think, that the broad finality of integration are no longer driving forces. To a certain extent, I follow Joseph Weiler, who suggests that the spiritual dimension of the European project is exhausted. The condition of integration is that of one without final destination. And so the question is, how then do we think about a sustainable process of integration involving European institutions, member states, and citizens without positing a federal whole, be it a telos or an ethos? That is, in my view, the challenge.
As I expected, Professor Azoulay guided us through this imaginative process of revisiting integration through law. He went through the main points that had characterized that project, the political process, this process of social inclusion, we may call it now, which has this strong tension towards human dignity, then the combination of theory and practice in comparative law, and this ethos based on the values of the person. So we have enough here to discuss, and the two discussants are, I'm sure, ready to open this discussion. And I think Marta will have the first go.
Thank you. Let me first thank the organizer for giving me such a wonderful opportunity. It's a pleasure and an honor to be here. I will take many of the illuminating insights that Professor Azoulay just provided us, and I will turn them into the perspective of integration of European private laws. Now, there is no need that I remind you of how much work has been done in the last decades at a variety of levels, in a variety of forms, for integrating European private laws. But what I would like to stress is that there could be little doubt that both those who study and those who participate in these projects would have much to learn from Cappelletti's teachings. And I would like to dwell upon some of Cappelletti's most solid and enduring lessons for the integration of European private laws. I'm mainly referring to the emphasis placed by Cappelletti on the dynamic and on the historical nature of the law, the need to respect diversity, the need of addressing societal power imbalances, and the responsibility of comparative lawyers and their duty to engage in applied comparative legal research. So, first of all, dynamics. Integration through law for Cappelletti is both a result and a process. In such a view, law is both the object of integration and an instrument of integration, a platform where the actors involved in the integration process discuss and shape their new role, places, and identities. This emphasis on integration as a moving process is a reminder of the dynamic and multi-layered character of the law, as well as of its identity value. For Cappelletti, law never stands still. Rather, law and society make and remake each other through ongoing dialectical relationships. And these relationships exist in a plurality of competing and overlapping order that stretch beyond and underneath the state and state actors. Through such interaction, law does not only govern the behavior of society members, but it also acts as a way, in Clifford Gertz's terms, as a way of imagining the real, as a way of, as a looking glass through which society can see itself and can see what it would like to be. Second, time. This idea of law as a process works also as a reminder of the importance of the time factor. Law lives through time and in time. For Cappelletti, what we are today and what we are striving to be tomorrow is a function of what we were yesterday. And in this light, integration processes are but one of the many places where pressing present needs call us for rediscovering and reinterpreting our past to reinvent our future. This time awareness also helps us not to forget that legal integration cannot take place overnight, but is rather the ongoing product of a history of stops and goes, acceleration and deceleration, division and unification. Third, diversity. In such a broad and long-term view of integration processes, there is obvious, and there should be, an ample space for diversity. For Cappelletti, diversity refers first to the variety, to the plurality of forms and results that integration processes may take and produce. But it also refers to the variety of legal systems and legal cultures that are involved in the integration processes. And the accent placed on diversity relates to the caution that Cappelletti places on against the risk of ignoring what he calls the beauty of diversity, and against the risk of eradicating, again, what he calls the value of legal pluralism through, I'm quoting again, dual or indeed oppressive uniformation and centralization. He stresses out that integration implies continuous struggles and compromises between unity and plurality, between centralization, decentralization, between authority and participation. Now, this takes us to the fourth point, which is law for and of people. It would be wrong to think that the accent placed by Cappelletti on the importance of diversity and on the importance of participation is only dictated by political realism. By contrast, respecting diversity and promoting participatory forms of polity are all ways to warrant that integrative processes are made by and for people. In Cappelletti's view, integrative processes are not value neutral. They should not be value neutral. Rather, they should be imbued with constitutional values, with human rights, protecting especially the less voiced, the disadvantaged, the mostly affected by societal, economic, and power imbalances. 5, lawyer's duty. this deep concern for real-world problems of real people, as in local settings as well as on the transnational scale, underlies Cappelletti's commitment to applied legal scholarship, where applied means devoted to find out solution to real problems of the real world. The engaged comparative scholar for Cappelletti should act as a social engineer, as a medium between society on the one end and political institutions on the other end. He should, as our chair recalled, the comparative lawyer for Cappelletti should search for foreign models that can be adapted to national problems and conditions while being constantly aware of the profound difficulties in seeking to tear institutions away from their legal culture and plant them in a foreign soil. The comparative lawyer should also pursue her mission with a clear sense of purpose and with full transparency about her own policy agenda, as Cappelletti did in his tireless efforts of promoting what he called our cherished values of Western democratic civilizations. Now, as this last quotation shows, the cherished values of Western democratic civilization, Cappelletti was much ahead of his time, as he was a son of his epoch, an epoch where the world was deeply divided by the Cold War, and an epoch in which the West easily appeared as the apex of economic, democratic, and legal development, and all the non-West was simply labeled as the rest, or confined at the periphery of legal debate, or at best targeted by the soul-saving and yet comparatively unfit efforts of the first waves of the law and development movement. In the spirit of his time, Cappelletti believed that legal systems could be assessed, thanks to comparative law, in light of their contribution to addressing societal problems. And it also believed the legal system could be evaluated as more or less efficient, more or less just, more or less developed. He saw comparative legal research as, I'm quoting, search for models to follow and for pitfalls and shortcomings to avoid. And legal integration as a process towards the selective choice of the best and most suitable principles and tradition found. The history of legal change would thus be a history of natural selection, a history of progress from a scenario where backward and inefficient rules prevail to another one where more and more legal systems become integrated and civilized. Underneath the aspiration of measuring legal system and of searching what is best lies another 20th century assumption, which is that there could be universal standards against which we can evaluate what is best, what is more efficient, what is most developed. These standards are enshrined in what Cappelletti calls, I'm quoting, our modern legal systems, our 20th century civilization. There is here a Western-centric view, which has many ripples. Let me just recall one. This way, in this vision, features that are relevant in the West, the individualistic notions of right, the emphasis placed on judicial adjudication, on the private-public law divide, the focus on state and state institution, the dichotomy between civil law and common law, all these features become the relevant legal world. And then this vision of law, which is heavily influenced by Western views, is projected onto other contexts, nurturing a distinction between what is Western, advanced, efficient, developed, and what is not, what is different, primitive, undeveloped, or at best, developing. Now, these postulates are common sense for much Western comparative law scholarship. But it is at least doubtful whether there is an established standard for measuring the law. Against which benchmarks? Defined by whom? Appreciated and evaluated by whom? Many have warned against the limits of looking through cost-benefit analysis for the search of what is best, and against the limits of drawing linear and progressive legal histories, from primitive to sophisticated and integrating legal systems. Others have criticized the faith in comparative law as the basis for scientific and objective knowledge. For this approach naturally tends to disguise and replicate ethnocentric bias. What I mean is that the risk for the so-called objective observer is to overlap the present contents of his own Western ideas with criteria of universal truth and logic. To be sure, the dangers of Western ethnocentrism might not appear to be great within the framework of integration of European private laws, or within the framework of integration of Western laws in general, such as, for instance, in the current negotiation for the Transatlantic Trade and Investment Partnership, where, let me say incidentally, many lawyers a la Cappelletti would be badly needed. But Western ethnocentrism, in the long run, might impair what we might learn from and give to other experiences, other integrative experiences, such as those carried out by the HOADA in Africa or by the Asian and Latin American groups working on the Asian and Latin America common principles of contract law. I'm closing, swear. To learn and to give, we need to keep listening and questioning. We need to keep feeding our curiosity with an open-ended and rigorous search for knowledge, as Cappelletti did. And we need to keep in mind, as I said at the beginning, Cappelletti's lessons, the dynamic and time-dependent nature of legal integration, the need for respecting diversity and addressing society's real problem, and the responsibility that we, as comparative lawyers, are entrusted with. These, I think, are the greatest lessons that Cappelletti left us with. Thank you.
Thank you. Thank you, Marta. I mean, it's a confirmation that integration is a moving process, as you said at the beginning of your comments. And really, I like the metaphor of the looking glass, because through the looking glass, we are really projecting future aims for this process. But I like the emphasis on the diversity and on the voices of the weakest groups that Cappelletti was trying to listen to very carefully. Now the floor is yours, and you have 10 minutes. Thank you.
Thank you. Thank you, Professor Azoulay, as well, for your contribution. I'd like to thank the organizers for inviting me to speak on this topic. I'm honored to speak here today, as many aspects of my research environment are in one way or another linked to the work of Professor Cappelletti. To steal a joke, he was my Dr. Großvater. However, as I have no intimate knowledge of his career, of Cappelletti's career, nor am I as familiar with his legacy as others present here, I hope to offer what you invite young scholars for. I will take a generational approach to European constitutional law. The generational perspective I would like to discuss is the legitimacy of one generation to place rules out of reach for future democratic majorities. Constitutional law is sticky and therefore requires an intergenerational justification. What gives one generation the right to rule over the next? In the US, this topic has received plentiful attention, but in Europe, it is not at the forefront of constitutional scholarship. Now, if we look at the introduction of the Integration Through Law project, as Professor Azoulay did as well, there are two observations I would like to make. Firstly, there is in the analysis on the dynamic between law and politics the idea that the extensive use of Article 235, the infamous flexibility clause, which was used to extend the competences of the community beyond the original distribution, was rather unproblematic, if I may summarize it like that, because of the strong involvement of governments in this procedure. This dynamic and this explanation can, of course, only hold in the stability of culture and political continuity within the member states. When governments with wildly different political preferences follow each other quite rapidly, the legitimation of extensive use of the flexibility clause decreases. That is because politicians can use the dynamic to lock in their policy preferences on the European level. And the well-known joint decision trap has therefore deep generational implications exactly because of its quasi-constitutional nature. Or rather, the observation on the dynamic of the use of Article 235 makes presumptions both about the underlying political culture of stability and the type of issues for which the decision-making procedure was used. Secondly, the object of study of the Integration Through Law project was the process of moving to integration. That is, the process of moving from a paper treaty to a physical reality of European integration. The ITL project took place at the end of an era of integration governed by the Treaty of Rome. I believe this timing is essential in the proper assessment of the project. After the project, there have been numerous treaty changes, but the project itself focused on integration without treaty change. It is therefore not surprising that the project focused on a dynamic of moving towards integration. The studies, and I quote, "The studies of the institutions and processes deal extensively with the actual operation of federal or transnational systems, and less with formal structures or procedures." The fruitfulness of this approach of looking at the pre- and post-normative phase, as well as the positivist account of law, must be subscribed. It has been very fruitful. We should be careful, however, in not confusing a good contextual description of law integrating the pre- and post-normative phase with an analytical account of how and where integration occurs. The Integration Through Law project, and repeated here by Professor Azelai, correctly states that integration is primarily and fundamentally a political process. Law has a vital role to play in this process, however. Professor Azelai also reminds us that integration through law is a concept that takes on a new meaning depending on the historical time in which it is formulated. I would argue that at least one of the differences in historical time is that after the Integration Through Law project, there was a surge of treaties, starting in 1986 with the Single European Act, and later Maastricht, Amsterdam, Nice, and eventually Lisbon. Integration after the project, therefore, has progressed by way of treaty making. Although these treaties have been highly ambivalent. On the one hand, they democratized internal EU decision-making by the reintroduction of qualified majority voting and the enhanced role of the European Parliament. But on the other hand, the treaties lay down in detail the goals and instruments available for each specific policy area. Purposive competences, as they have been named. Consensus at the treaty-making stage was therefore bought at the expense of flexibility for future generations. Now I have to make a small detour here in order to fulfill the requirement of making at least one comparative analysis. One of my favorite anecdotes about US constitutional law is about Justice Hugo Black. Every single day, or so the story goes, he would carry a paper copy of the Constitution in his pocket. When asked what restrictions the government could place on free speech, he would get the copy out of his pocket, read the First Amendment, and say, "Congress shall make no law abridging the freedom of speech." My point is not that we should copy his interpretive methods. I want to point to the fact that he was able to carry a paper copy of the US Constitution in his pocket. I only hope that none of you carries around a paper copy of the EU treaties in their pocket. So I would like to propose the Justice Hugo Black standard of what is a constitution. It should fit in your pocket. It works for the Dutch constitution, I would only hope that in the future it will also work for the EU treaties. The treaty, as our constitutional charter, regulates a lot of things that are usually not regulated on a constitutional level. Case in point is the euro. No European constitution had or has such detailed rules about its money as the EU treaties. Looking at the euro crisis, we of course cannot ignore the processes and institutions, the informal interactions, the actual integration, the changing power positions between the institutions, the interpretative shifts with regard to the no bailout clauses, and the new economic governance all require a renewed investigation into the legal framework of our common currency. The EU treaties alone do not tell us anymore who governs the euro. However, we equally cannot ignore the formal constraints and procedures as created by the Maastricht Treaty. It is from the constraints found therein that the euro crisis has evolved, a term that is specifically appropriate for the crisis. The deeply problematic situation that has arisen now in the deadlock between courts and the ECB being forced in what I would call legal speak is a direct result of the enshrinement of the complete legal framework of the euro into the treaties. It is in the battle over the interpretation of these provisions of EMU that the response to the crisis has progressed. That the Bundesverfassungsgericht is now able to apply an ultra-virus test with at least some notion of credibility is only possible due to the original sin, if I may call it that, of inscribing the detailed legal framework in the treaty. Professor Azoulay spoke about the developing parallel relational space that has developed in the euro crisis and sees this as a sign of distrust in the EU institutional machinery. I do not disagree with the first part of the observation, but I would point out that the move to go outside the treaties is a reaction to the original decision in Maastricht to preclude the development of a meaningful space for monetary and economic politics inside the EU political sphere. Politics within a constitutional order is only possible if that constitutional order leaves enough room for a responsible politics to develop. I come to my final point. Discussing constitutional law from a generational perspective is not exactly new. As I said, the generational angle has been particularly well developed in the US, especially with the unfortunate rise of originalism in the last decades, but it has its foundations well before that, with Thomas Jefferson being the most eloquent in rejecting the continuity of constitutions. That is why, during my research, I have marveled at the lack of criticism from constitutional scholars on EMU in the first years of the 1990s on this point. There have been numerous publications, media performance, open letters by economists saying the economic ideas behind the euro are flawed. Why have there not been constitutional scholars saying the legal ideas behind the euro are flawed? I'm not talking about the economic wisdom of the euro, I'm talking about the legal wisdom of allowing economic ideas to be written so comprehensively and extensively into the treaty. The lack of criticism from the wider legal community is something I fail to comprehend. Maybe it is the result of a generational gap. And I'm doing some injustice here, as there have been a few lone voices critiquing the amount of detail in the treaties, and from those who feared that EMU would drag the courts into areas best left to politicians and central bankers. But overall, I think EMU was perceived enormously favorably by a large majority of constitutional scholars. But given the restrictions, the language restrictions of myself within comparative perspective, I am very much open to be disproven on this point. To conclude, constitutional law connects one generation to the other. Constitutional law is an indispensable instrument in creating reliable, stable, and accountable governance. For the euro, however, I fear that the instrument has been abused. Hence, I am deeply skeptical of current calls by many legal academics for responsibility for collective choices as a way of progressing out of the euro crisis, not because out of disrespect for the rule of law, but because I doubt the legitimacy in the form in which those collective decisions were taken. If constitutional law is about passing down wisdom from one generation to the next, we shouldn't be surprised that in the case of the euro, there is some resistance.
Thank you. Thank you so much for your generational approach, which is also reminding us of the danger of a generational gap, which I think came out very nicely from your discussion. Thank you also for contextualizing this discussion within historical developments and so many treaty changes which make it very difficult to carry the treaty in the pocket. I agree with you. But apart from this, let's see whether we can open the discussion now. We have really so many points being made, and there is, I'm sure, an interest in Joseph, do you want to start? I'm also told, and I'll say this in Italian, che c'è la signora Silvia Calamandrei in questa sala, e naturalmente se vuole prendere la parola per noi sarà una grande gioia ascoltare la sua voce. Non so se vuole prendere la parola ora o dopo, quando la discussione ha preso il via.
No, signor. Grazie. Posso parlare? Grazie di darmi la parola per un saluto a questo pubblico, a Matilda Cappelletti, la figlia di Mauro, e a tutti voi per ricordare a 10 anni di distanza il grande contributo, l'eredità che Mauro Cappelletti ci lascia. It's my pleasure to address you as the granddaughter of Piero Calamandrei, who was the professor of Mauro in his studies here in Florence. By the way, maybe it's not one of the issues dealt with here, but for Italy it's very important, the work, the scientific work of editing that Mauro Cappelletti did for the juridical works of Piero Calamandrei, 10 volumes that he took care of, and we find the traces of this work in his archives. In 2009, Matilda Cappelletti, his daughter, was kind enough to donate to our archives in Montepulciano, where we keep part of the documents of Piero Calamandrei, 4 boxes of documents that Mauro was keeping in his house, working on the subject of editing the works. And now it's a great pleasure that we had when in the new donation that Marta has done towards the European Institute here in Fiesole, among the papers of Mauro that will be subject of study for all the students, there are also again some papers belonging to Calamandrei, a correspondence dating from the beginning of the 20s to the 40s between Chiovenda, Calamandrei, and Carnelutti that is of great interest. So it's my pleasure to know that these documents are kept, thanks to the generosity of Matilda, in the Institute and will be a subject of study and cooperation between the different institutions. Let me give a few personal details, as here we are dealing with Mauro rather on the scientific side, but I would like to say that I met him in the 50s when he was a young student. Piero Calamandrei had just died, and he was one of the few people that my grandmother was welcoming at home And so I met him when I was 9 years old. Then I had the pleasure to meet him again and to exchange letters with him when I was working in the European community. And now I deal with certain subjects that we are discussing today. I think that working as I was at that time on environmental protection and consumer protection legislation, Mauro work was of great importance. So when it was just said that Mauro was looking forward, I find that many of the approaches that he were anticipating already in the 80s and in the 90s could be of great use today. Often in Italy, in the debate on Calamandrei, it's said that he was looking forward, aveva una visione presbite. I think that Mauro inherited that vision of looking forward towards the problems of the future, and to try to have a paper, a constitution to keep in the pocket. I would say that the Charter of Nice could be a first start, not all the heavy treaties, but if Europe has a future, it's going along that way. Thank you so much.
Siamo noi che la ringraziamo per questo intervento così appassionato che ci ricorda una visione presbite che dimostra come il passato è veramente molto vicino grazie al lavoro di questi grandi maestri. Quindi grazie per il suo intervento. Ora, I think Joseph wanted to take the floor.
Thank you very much. So it's of course impossible for me not to also involve a bit of the personal. Louis Casolai had two choices. He could either have looked at the entire architecture of the Integration Through Law project, or look at the introduction at the synthesis of this. And he focused on the introduction, and I will come to that in a minute. But I want to say something about the general architecture. It was Mauro's idea, the project. And the general architecture was entirely Mauro. So the basic idea, the human value in European integration and not just treat it as a technical thing. The fact that it had to open with the political and the economic, something that today seems so obvious, but then was revolutionary. That's Mauro's idea, and that shaped me forever. The insistence on the comparative. Now, we have to insist again and again. It used to enrage us when the first reviews started coming out, and people who read the project superficially would say, but Europe is not like the United States, making an assumption that because it was Europe and the American federal experience, Mauro took the United States as a model for Europe. It's totally false. He never took it as a model for Europe, but he had a deep belief in the value of comparative analysis, that you think differently when you do comparative law, because it challenges the assumptions you have about your own system. And that was for him the value of doing Europe in the light of the American experience, rather than America as some kind of model, or the more sort of laboratory, we can learn what works and what doesn't work. It was a belief in the epistemology of comparative analysis as reaching deeper insights. That's Mauro Cappelletti. And then the choice, the division between the essays that walked through the various aspects of European integration and then the volume. So a volume on the environment, a volume on consumer protection. That was his way of linking his previous project on access to justice to the integration project. And finally, you know, I started working with him when I was 28. I was doing my doctorate. So I would come to him and say, there's incoherence here, and this author is not the right person for this subject. He's not an expert even in the field. Why are you inviting him to do it? You know, the sort of vices of youth. And I remember Mauro looking at me and said, Joseph, you know, with that strong Italian accent, he spoke English. Forget about all this. If you get first-class people, you will have a first-class project. That was also entirely Mauro Cappelletti, that the most important thing in designing a project was to get first-class people to participate in it, and that was more important than the strict coherence or systematic. You know, we're not writing a German Kommentar. We're thinking deeply, so get people who can think deeply. The introduction is a different story. It was a gift of Mauro to Monica and I, because, you know, you're a research assistant. You do scientific work, but you also write letters and photocopy. That's what research assistants do. And we did that faithfully and loyally. And at a certain point, he said, you get to write the introduction to the project. It's not like a judge with clerks, here are my ideas of the judgments, now just write it up. Think about it. It's a different relationship of master and pupil. It's total trust. You get to write the introduction to this project. I will give you some comments. Obviously, you're influenced by my ideas, but there's trust, there's loyalty, there's a belief that there's a relationship between master and pupil. Talk about the generational gap. So that was his great gift to us. And that's why listening to Loic today was not an easy experience for me, because it was a little bit like being on the psychoanalyst's sofa. Here is something that Monica and I wrote. I was a young person, and I think it was brilliant. He got it right, but I tell you, for example, it's uncomfortable in the sense you think that in 30 years you will change and develop. And the psychoanalyst comes and says, here are your deep personality traits, and you're going to live with them for the rest of your life. And listening to him, he just hit the nail on its head in relation to so many things. For example, it was a deep resistance to Pescatore and the market. Now, I had a very difficult relationship with Pescatore. On the one hand, it was admirable. When I applied for the job of assistant professor in the department, Mauro said to me, it's just going to be an exercise for you because Pescatore is the chairman of the jury and he has recommended somebody from the European Court of Justice, so obviously that person is going to get the job. You know, that's how the world works. And then we sent to Pescatore my working paper, Supranationalism Revisited, and Mauro did something inappropriate. He showed me the telex, you know, that's the age of the telex, that Pescatore wrote back, and he said, I got this paper, obviously Weiler should get the job, not the guy that I was recommending. It's also a lesson for life that I learned. But Pescatore distrusted me, and I did not like the market approach. That is true. I still don't like the market approach. I didn't like the way the human being was instrumentalized. It was about human dignity, etc. So you hit the nail on the head there, for example, in that respect. But I want to make two additions. It's a deeply Jewish introduction in two senses. First of all, the idea of the federal. And that I learned from Dana Lazar, and it's worth your while going and reading Dana Lazar. It's the first contribution to the project. Dana Lazar traces the federal idea to Ferdus and then to idea of covenant. What is essential? What is the concept of the federal that we try to write in the introduction and that has remained a constant with me? Imagine the following conversation between God and the people in Mount Sinai. So God says, here is my law, I offer you this covenant. Will you accept it or not? And the people say, why covenant? You are God, you are the creator, you are the King of Kings. Tell us what to do and we will obey. And God says, no, 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 I want a covenant. And they say, but anything you tell us, we will do. I want a covenant. Why does he want a covenant? I want you as equal. I want you as sovereigns. You have to accept it. It's not by command, it's by acceptance. It's a partnership of equals. That's my understanding of the essence of the federal idea. It's a partnership of equals, and it means an inbuilt and continuous tension and contradiction, because a partnership of equals, rather than a hierarchy, breeds a continuous structural struggle and tension. So that is a little addition, although you identified correctly that the federal idea was central. Identity, I agree with you, and it just explained to me why later I wrote that book, A Christian Europe. It was in search of identity. But there's one thing that didn't come up in your analysis of the introduction, which I would like to bring out. It's the idea of law as a value in and of itself. And that, again, nomos, is a very Jewish idea of the law. Law is not an instrumentality. Law is not just the technical means by which you translate a policy into a command in order to achieve a certain result. Rightly or wrongly, I mean, that's, St. Paul obviously thought wrongly, but rightly or wrongly, there's a deep belief in the value of law in and of itself. That law is a means for liberty, that law, unbounded liberty, leads to barbarism. It's a self-constraint, etc. So integration through law is not just taking law as a technicality to achieve certain means of integration, the market or whatever you want, but integration through law means it's integration through law as a value in and of itself. You do things through law, you do things through justice, because law embodies values which are inherent to the very idea of law. And that is also something that one tried to convey in the introduction. And the truth is, as you said, that inevitably there's a certain disappointment in the current circumstance of Europe. Thank you.
Well, thank you very much for this very rich comment, which makes me think on how interesting to see that scholarship at the EUI is subject to psychoanalytical tests, and how we're dealing with a father-son relationship, which is somehow more intriguing than the usual mother-son relationship. But do you want to react immediately? We don't have too much time, because I'm told we are going to lunch at 12:30. But I do feel the need of asking the audience if there is any short question to put to the panel here. There is a short question there. Okay, we'll take this one, and I don't see, and another one here. Okay, Bruno.
Just trying to be quick, taking advantage of your presence here and integration through law is the topic. So I'm wondering if we could say that if you look at integration to law from an historical perspective, we can say that starting from the Corpus Juris, that has been a sort of a way to integrate the law. Then there has been a period of barbarian invasions, disgregation of the law. Then again, Bologna, 12th century, Irnerio, Bartolo, and all the others, the creation of the Ius Commune. Then again, absolutism, the creation of the national civil codes. Then again, the process of the European integration. Can we just, for discussing that there is, in Vico's term, a coursy and recursive things coming on two sides. So also integration to law is now facing a possible decrease, and then a new rebirth will come. Just quick.
The speaker is Dr. Guido Boni, who forgot to introduce himself. There you go. Bruno De Witt.
Yes, so when looking back 25 years later at the European integration through law project, the speakers have expressed a sort of sense of disappointment, I guess, in the role of law in European integration. If I can summarize Loic's intervention, it's mainly saying, well, European law has lost its soul. It's a very sort of summary view of what he was saying, so it's no longer law which provides a sense of order in the integration process. It's a source of disorder, you could say. And then Marijn saying there's too much law. So there's too much law, which is an obstacle to integration in a sense. So two rather pessimistic accounts. And I was wondering how you would see evolutions such as what was mentioned by Calamandre's granddaughter, the adoption of the EU Charter of Fundamental Rights, one of the recent developments. How do you see this from your perspectives, your, let's say, pessimistic perspectives? And secondly, how do you see the lawmaking capacity of the European Union if you compare it with the American federal capacity of lawmaking, which has gone down to zero, basically? We still see the European Union legislating through this complex process of co-decision, so able to make new laws in a way which is much more impressive and efficient than what we see in the American federal system today.
I think perhaps we have to stop here for taking questions and give the floor again to Loïc. And
I'll be brief. To Joseph first. If there is a need to react, it was very insightful what you said, but my presentation and the paper are not conceived of as psychoanalysis. Actually, you have two, Joseph, you have two places in my paper. One is related to the description of the project as I see it from the introduction. So indeed, the federal principle, mainly. And then you are there at the end of my speech, which actually it's where the paper starts. That is when I say that we need to move forward. The ethos, or at least the idea of finalité, is no longer sufficient to make sense of this project. And so we have to find an approach and a way to conceptualize integration to make it a sustainable process. So I see you in two different places. Conceptually, I mean. I see you moving, and this is reflected in the paper. Just to mention that I don't ascribe you to one place. Now you said what European law delivered is a bit disappointing, and this relates to Bruno's question too. I should say, maybe I should say as an assumption, I still believe, at least in the analytical power of law, to try to make sense of this process. My presentation did not aim at being so pessimistic, but pointing into a direction where we should now try to focus and find a new way, both in substantive terms, what is the meaning of integration, and in methodological terms, which approach are we going to take to find this meaning. But my question would be, and a question I asked myself is the following: is it still a legal question? It's still a legal question. Isn't it the case that now we should, and it's a serious question, that we find in the literature, and not only in the literature, that we find in the street, everywhere in Europe. If the integration is in a way distorted, or does not deliver to the European citizens, or produces forms of inequalities, isn't it the case that this should lead to protest, or in terms of approach to critique? That would be my questions. If European law has been so disappointing in terms of European identity and federal principles, is it the case that we should now analyze integration through protesting, critique? And you know that we find in the literature now a stream of critical studies, and so that we find everywhere in Europe a strong critique of the project. And my answer to that in the paper, true, not in the presentation, my answer to that is that critique should be taken on board. We should of course, rely and include a critical approach and a critical activity within our methodology to analyze the integration process, but that's not enough. That's not enough because if we only rely on critique, then our scope of analysis will be very narrow. We'll focus only on certain aspects of integration. And so what I think is that we need a new concept of law and a new concept of integrations which looks at integration as a field of contradictions, as a field of ambivalences. And we have to take this seriously. So that would be my take. Now, as for the charter, and I'm very short, for the charter is great as an important document. It may orient some lives. It may guide interpretations. But you know, Bruno, don't forget that the charter has been discarded in many instances, especially in the case of in the Pringle case, in cases where there is a common point between Pringle, where the member states act outside the institutional framework, and Dano, the recent decision of the court, when the Court of Justice is very strict on citizenship rights. What is common to both judgments is the fact that the Charter is not applicable.
Thank you. I think we are all very grateful to this fantastic group of speakers here, and are also grateful for the critical remarks that you put in as a conclusion. I think this is probably the purpose of this conference, that we have to read critically through the work of Mauro Cappelletti. I'm sure that he would have liked this discussion very much. Thank you very much. You want to join me with an applause? And we go now to lunch in Sala d'Arme.